The Honourable the President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honourable Senators, first may I say Happy New Year to everyone. Honourable Senators, I have granted leave of absence to Senator Daniel Duque, who's out of the country, and to Senator Nigel de Freitas, who's ill. Honourable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Ndale Young, whereas Senator Daniel Duque is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be temporarily a member of the Senate with effect from the 15th of January 2019 and continuing during the absence from Trinidad and Tobago of the said Senator Daniel Duque. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's this 10th day of January 2019. To Mr. Augustus Thomas, whereas Senator Nigel de Freitas is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Augustus Thomas, to be temporarily a member of the Senate with effect from the 15th of January 2019 and continuing during the absence of Senator Nigel de Freitas by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's this 15th day of January 2019. Honourable Senators, Senators are required to take the oath.
I, Ndale Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago and will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
I, Augustus Thomas, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Representatives, as on the supplemental order paper, the Administration of Justice Indictable Proceedings Amendment Bill 2018, in the name of the Attorney General. Papers.
Minister of Trade and Industry.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper in my name. The Annual Administrative Report of the National Flour Mills Limited, NFM, for the year ended December 31st, 2017. The Consolidated Audited Financial Statements of the Trinidad and Tobago Bureau of Standards for the year ended September 30th, 2017. The Unconsolidated Audited Financial Statements of the Trinidad and Tobago Bureau of Standards for the year ended September 30th, 2017. Thank you.
Minister of Works and Transport.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers are listed on the order paper in my name. The annual report of the Trinidad and Tobago Civil Aviation Authority for the period 2017-2018. Thank you.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The Consolidated Audited Financial Statements of the Union Estate Electricity Generation Company Limited for the year ended December 31st, 2017. The Annual Report of the Trinidad and Tobago International Financial Center Management Company Limited for the financial year ended September 30, 2018. The Annual Audited Financial Statements of the Trinidad and Tobago Tourism Business Development Limited for the financial year ended December 31st, 2017. And the Annual Audited Financial Statements of the Youth Training and Employment Partnership Program Limited for the financial years ended September 30, 2015, 2016, and 2017. Thank you, Madam President.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Vice President, the Minister of National Security, and the Minister of Public Administration. The Annual Report of the Police Service Commission for the year 2015. The Annual Report of the Police Service Commission for the year 2016. The Annual Report for the Public Service Commission for the year 2017. The Ministerial Response of the Ministry of National Security to the 8th Report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd Session 2017-2018, 11 Parliament, on an examination of the perceived inequality faced by single fathers in Trinidad and Tobago, with specific focus on custody matters, policies, and access to programs and services. The Ministerial Response of the Ministry of National Security to the 9th Report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd Session 2017-2018, 11 Parliament, on an inquiry into the treatment of detainees and conditions at holding cells in Trinidad and Tobago police stations. and the annual report of the Telecommunications Authority of Trinidad and Tobago, TAT, for the year 2017.
Reports from committees.
Senator Dylan Remy.
Thank you, Madam President. Madam President, I have the honor to present the following report as listed on the order paper in my name. The third report of the Joint Select Committee on Foreign Affairs, 4th session 2018-2019, 11th Parliament, on the circumstances surrounding Trinidad and Tobago's vote at the Permanent Council, Organization of American States, OAS, on the request by the government of the Commonwealth of Dominica for a waiver of its contribution to the annual budget of the OAS on March 23, 2018. I thank you.
Senator Mark.
Thank you, Madam President. Madam President, I have the honor to present the following reports as listed on the supplemental order paper in my name. The 13th report of the Public Administration and Appropriations Committee, 3rd session, 2017-2018, 11th Parliament, on an examination into the administration of special health care programs in Trinidad and Tobago. And the 14th report of the Public Administration and Appropriations Committee, 3rd session, 2017-2018, 11th Parliament, on an examination into the construction, maintenance, and refurbishment of state-owned or state-funding housing projects and units.
Minister of Agriculture, Land and Fisheries.
Thank you, Madam President. Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The interim report of the Joint Select Committee appointed to consider and report on the Cybercrime Bill 2017, 4th session, 2018-2019, 11th Parliament. I thank you.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The interim report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016, 4th session, 2018-2019, 11th Parliament. Thank you, Madam President. Urgent questions.
Madam President, I seek your leave to request that this item be deferred to later in the proceedings as the 2 urgent questions posted to the Minister of National Security. He's unavailable at this time, but he should be available at around 3 p.m.
Honourable Senators, this item will be deferred until later in the proceedings.
Questions on notice, questions for oral answer.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government seeks a deferral of the following questions. Question 13, 14, 39, 40, and question 101. The government will be answering all other questions listed on the order paper. We seek a deferral for 2 weeks.
Questions number 39, 40, 101, and 101 will be deferred for 2 weeks. Senator Ramdi.
Madam President, before I pose the question, I think I heard the Leader of Government Business ask for a deferral of 13 and 14. Okay. Question 15 to the Minister of National Security.
Leader of Government Business.
No, didn't I say? No, well, my apologies, Madam President. We also seek a deferral of 15 and 36. My apologies.
Senator Ramdeen, question number 37.
No, Senator Mark.
Oh, Senator Mark.
Oh, Senator Mark, question number 37.
Thank you. Question number 37 to the Honorable Minister of Social Development and Family Services.
Minister of Social Development and Family Services.
Madam President, during the 6-month period, October 2017 to March 2018, the Ministry's Division of Aging received 72 reports of cases of elder abuse. 30 of the reported cases allegedly occurred at geriatric homes and 42 at private residences. Inspectors attached to the Division of Aging conduct random visits at all geriatric homes to identify instances of abuse or non-compliance with established standards and to provide advice and guidance to residents, staff, and owners. Upon receipt of reports of elder abuse, the Division of Aging conducts unannounced visits and inspections at both geriatric homes and private residences. Unannounced inspections were conducted at the 30 geriatric homes. During our inspections, we were either unable to substantiate allegations of abuse or found no evidence of abuse at 27 of the homes. We, however, identified instances of non-compliance with established standards in the areas of safety, environment, staffing, policies and procedures, and record keeping. In this regard, the homes were required to sign compliance agreements that will address their respective deficiencies within an agreed time frame and are being monitored by the Division of Aging. In addition, 12 homes were referred to the Ministry of Health for registration and 9 for urgent or immediate action. Verbal abuse was found at 1 home, and the matter was referred to the Trinidad and Tobago Police Service. At 2 homes, poor, inhumane, and/or unsafe conditions resulted in the decanting and relocation of all residents. The owners of these homes were also referred to the Ministry of Health. The 42 private residences were also visited by inspectors of the Division of Aging, who were accompanied by the police where necessary. 21 of the reports of abuse could not have been substantiated or confirmed. 4 of the alleged victims were, however, referred to the National Family Services Division for psychosocial support, including counseling, and 2 to the Social Welfare Division for assistance. 21 instances of abuse were confirmed. 4 of the victims were relocated to reside with relatives and 9 to other geriatric homes. In 5 instances, caregivers were removed and 3 matters were referred to the Trinidad and Tobago Police Service. The ministry also implements seminars, workshops, and outreach programs on the issue of elder abuse to educate and build awareness. Since 2006, the ministry has been commemorating World Elder Abuse Day to raise awareness of related issues and to help eradicate such practices. The Ministry of Social Development and Family Services also highlights the OPIC and services available for elders on the ministry's website and collaborates with other agencies to educate and inform the elderly and other members of the public on the various agencies and services available to treat with elder abuse. I thank you, Madam President.
Senator Mark.
May I ask the Honourable Minister what recommendations, if any, the ministry, that is your ministry, would have advanced to ensure that these private homes do not continue with abuses of the elderly? Can you share with us recommendations and plans for implementation?
Minister.
Madam President, when abuse is identified, the ministry identifies the specific abuse and makes recommendation to treat with those specific areas of abuse. We also have the respective homes sign compliance agreements. These agreements contain action plans in terms of what actions are to be taken to eradicate the abuse, and we monitor them continuously.
Senator Ramdeen.
Thank you, Madam President. Honourable Minister, Madam President, through you to the Honourable Minister. Honourable Minister, having regard to the matters that have been referred to the police, can you tell us how many, or is the Ministry aware of if any prosecutions have been commenced against those persons in relation to those matters that you indicated were referred to the police?
Minister.
Madam President, we are not aware of whether those matters have gone to prosecution. After we have referred the matters to the police service, that is where the ministry's action stops.
Senator Amin.
Thank you, Madam President. To the Minister, as a follow-up, how would these findings affect the funding that goes to some government funding that goes to some of these homes? How will the funding be affected based on the recommendations?
Minister.
Madam President, based on our records, none of the homes where we had to remove residents were being provided with a subvention by the government.
Senator Mark.
Can I ask the Honourable Minister, what is the time frame for these compliance agreements with these homes, whether they be private or otherwise? What is the time frame normally?
Minister.
Madam President, the compliance agreements have different time frames, and it varies based on the extent of the deficiencies identified. So you may find some of them varying from 3 months, some of them goes as far as 12 months. But it depends on the extent of the deficiencies that we would have identified at the various homes.
Senator Ramdeen.
Madam President, through you to the Honourable Minister. Honourable Minister, having regard to what you've indicated as to the state of these 72 senior citizens who have been moved and victims of abuse, what steps have been taken by the ministry to ensure that throughout Trinidad and Tobago, where these homes are located, that these matters don't repeat themselves to the detriment of the persons who are housed at these homes and institutions?
Minister.
Madam President, the inspectors attached to the Division of Aging are required to visit and inspect all homes. These homes are normally inspected. We try to do inspection at least once per year. Sometimes it may not be possible because of the number of homes that we cover, but the intention is to conduct random inspections at all of these homes throughout the year.
Next question, Senator Mark.
Question number 38 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, in July 2018, the PTSC receives funding which was used to cover amounts owed to suppliers for spares and for the purchase of new spares. The PTSC continued to work through the Ministry of Works and Transport to secure funding from the Ministry of Finance to acquire much-needed spares for the maintenance and repair of buses. In recognition of the aging fleet of buses at the PTSC and the rising cost of maintenance of these buses, Cabinet approved and PTSC received 35 new buses in March of this year, 2018. An additional 25 buses are expected to be received in fiscal 2018-2019. In addition, Cabinet has also given approval for the purchase of 300 new buses for the PTSC as part of its bus fleet renewal program. Over the fiscal period 2019-2021, the acquisition of these new buses is expected to alleviate the current issues faced by the traveling public. Madam President, it is the aim of this government as part of Vision 2030 to ensure a relief, safe, and accessible transportation service for all our traveling public. I thank you.
Senator Mark.
Madam President, can the Minister indicate how have these shortages of spare parts to PTSC buses impacted on the traveling public? Can you share with us the crisis or the challenges that the spare parts shortages would pose?
Senator Mark, I won't allow that question. Senator Ramdeen.
Thank you very much, Madam President. Through you to the Honourable Minister. Honourable Minister, having regard to the answer that you gave, can you indicate just by an average what is the difference between what has been requested by the ministry under this head, which is for the repairs of spares to the PTSC buses, and what has been provided by the Ministry of Finance to your ministry?
Minister.
Madam President, I can't give you an exact figure at this time. However, it was only yesterday at the other place I answered the question that the PTSC did receive its funding, and it was actually at the end of the financial year as that saving, a difference that was not utilized. So we did get the funding, we did buy the spares, and I can tell you that PTSC's fleet is up to 260 with the refurbishment of the existing buses being done in-house. Thank you.
Senator Ramdeen.
Having regard to that answer, Minister, you said it's up to 260. How many are still in need of repairs to bring the fleet up to service?
Minister.
Madam President, I did indicate that the fleet at PTSC, some of the buses are 20 years, 25 years, 15 years with a lifespan that should be about 10. So we are at the point now where we are bringing in new buses because it is not economically viable to repair the old buses. And this is why the government took a decision to bring in 300 new buses so that we can bring the fleet up to close to 500. Thank you.
Senator Mark.
Madam President, can the minister indicate whether or what system is in place at the PTSC to ensure that spare parts that are purchased are properly secured and not pilfered? Can you share with us?
Senator Mark, that question. Yes. Next question, Senator Obika.
Thank you, Madam President. Question number 69 to the Minister of Trade and Industry.
Yeah, Madam President, this question was redirected to the Minister of Community Development, Culture and the Arts, and I respond on her behalf. In May 2018, Cabinet agreed that the governance and management arrangements of NAPA be placed under the remit of a single entity, the Ministry of Community Development, Culture and the Arts. Prior to this, the responsibility for the NAPA was shared amongst different agencies. In this context, proposal to operate the hotel wing of the NAPA was invited by the Ministry of Trade and Industry from the private sector, and a preferred hotel operator was selected. Negotiations with the preferred operator are in their final stages, and barring unforeseen circumstances, the hotel at the Napa is expected to open for business later in 2019. As a consequence, parts 2 and 3 of the questions are not applicable at this time.
Senator Obika.
Thank you, Madam President. Could the Honourable Minister indicate who was the successful operator that they are negotiating with?
Minister.
Yeah. Cara Suites was the successful preferred operator, and negotiations are well advanced for the final agreement.
Next question, Senator Obika.
Thank you, Madam President. Question number 73 to the Minister of Agriculture, Land and Fisheries.
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam President. Madam President, the Ministry of Agriculture, Land and Fisheries has received no requests for import permits for cattle from South America to be brought into the country via the Southwestern Peninsula. Having said that, Madam President, I'm aware of reports of the illegal importation of cattle that the Ministry provides support to law enforcement to deal with from time to time. Madam President, I thank you.
Senator Obika.
Thank you very much, Madam President. Could the Honourable Minister indicate if the Ministry has an idea as to the count of cattle that has been imported or reported to have been imported?
Minister.
Madam President, unfortunately, the Ministry has no such count. Thank you.
Senator Ramdeen.
Through you to the Honourable Minister of Agriculture, Lands and Fisheries. Minister, are you satisfied with the steps that law enforcement has taken in order to stop this illegal smuggling of these animals, cattle, inter alia cattle and others, from the at the Southwestern Peninsula?
Senator Ramdeen, I won't allow that question. Senator Obika.
Thank you very much, Madam President. As the Honourable Minister passed this information to the Ministry of National Security, given concerns that the cattle is used for drug smuggling.
Minister.
Madam President, the information moves in exactly the opposite direction. Ministry of National Security is responsible for the borders, and the ministry provides technical support to the Ministry of National Security on matters of smuggling, where the ministry has to provide advice on the animals, the state of the animals' health, the risk of diseases, and so on.
Senator Obika.
Thank you very much, Madam President. Then, in light of the Minister's response, could the Honourable Minister indicate if any party or parties have been or are under investigation regarding the illegal importation?
I won't allow that question, Senator Obika. Next question, Senator Dialsing.
Thank you, Madam President. Question number 83 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you. Madam President, in fiscal 2017-2018, the Drainage Division undertook a comprehensive desilting watercourse program called the CDWP. Under this program, over 296 desilting projects at various locations were completed, resulting in tributaries and main watercourses throughout Trinidad being successfully dredged. A detailed list can be provided if requested.
Next question, Dialsing.
Question number 84 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you. Madam President, again, the issue at Greenvale Park, La Hoqueta are complex and require a thorough investigation before the Drainage Division can recommend a solution to the problem that this area is currently experiencing. In other words, both internal and external drainage problems may be the issue. Currently, a full investigation is being carried out by various sectors of the Drainage Division, and on completion, the best solution for effective flood mitigation would be recommended for consideration. It is to be noted also that the internal drainage concerns are an ongoing matter with the HGC and are being addressed by their consultants. The recommendations of the consultants will also feed into the comprehensive solution for the park as well as sub-catchment areas. Part 2. The El Socorro South both gates and pumps have been earmarked for replacement. Under the program of upgrade and existing drainage pumps and gates inventory, this 2-year program was approved by Cabinet in 2018. And in the absence of unforeseen delays, it is expected that the program will be completed by the year 2020. Part 3. With respect to Real Spring Valsine South, there exists a flap gate system as opposed to a pump and gate system on the Valsine main drain, which takes runoff from the Valsine South area. The Valsine main drain is a tributary of the Guayabal River. Part 4, Madam President. As stated in my response to Part 1 of the question, a comprehensive solution to the issues of Greenvale Park, La Hoqueta is being looked at. With respect to Part 2, a defined date for the replacement installation of the gates and pumps is not available at this time. As stated in my response, Part 3, the question of installation of automatic sluice gates does not arise since a different system exists. I thank you.
Senator Richards.
President, can the Honourable Minister indicate that while the assessment is ongoing for the drainage situation at Greenvale Park and other areas that may be flood prone, if there's any imminent danger in those areas?
Madam President, we would recognize that we are now in the start of the dry season. And in the dry season, it is not expected to get that volume of rainfall. However, I can give the assurance that the work has started. We are doing surveys now in the Arima River and the Caroni area, which flooded the Greenvale Park, to assess where the banks need to be raised. And the HDC is continuing to do their work inside the development. So the work has started, although the consultations, everything is happening at the same time. Thank you.
Senator Teemal.
Question to the Minister through you, Madam President. In terms of the pumps and controls that are being installed, that are being looked at for El Socorro and other areas, to what extent would automation be implemented? Because I recall from some reports that there weren't personnel to turn on the pumps and all those things in Bamboo. Are we looking at automation together with all the installation of the pumps and everything?
Minister.
Thank you. Through you, Madam President, we do have a program for the upgrade, and in certain areas they will be looking at. We do have automated pumps operating in one of the Bamboo areas. Unfortunately, at this time, and the challenge with funding, we have to ensure that we have pumps that is working. What had happened in the past is that when you have that volume of rainfall, if you have the pumps and the land is flooded and the water courses are high, you cannot put the pump on. So there's a myth that if the pump is off, nobody went to put on the pump and things like that. You can't pump if the rivers are high, because you'll be pumping the water into the river and then it breaches back and come back onto the land. You have to wait for some sort of regulated area before you could start the pumping. So in the last flood, I can tell you, for the first 2 days, they could have done no pumping. Thank you.
Senator Richards.
Thank you, Madam President. Through you once again to the Honourable Minister. I know you indicated earlier on that we are entering the dry season, but given the climatic changes we've experienced around the world, we may not be able to have the comfort of not having erratic weather patterns.
Senator Richards.
So the question is there an urgent timeline on the assessment of these situations?
Thank you. Thank you. Madam
Minister.
Madam President, the urgency of the Greenvale area and some of the other areas in Trinidad is of utmost importance to us. However, in order to identify the solutions going forward, we have to do proper surveys to see exactly where we need to fix the breaches and so. We do have a challenge on the Arima River and the Caroni River, where citizens would have built construction on the entire bank, and it poses a access challenge to get to the affected areas. But I can give you the assurance that the ministry is working feverishly with the HDC to ensure that we have this area worked on in the shortest possible time. As a matter of fact, I can tell you there's a meeting carded for tomorrow with the Drainage Division and the HDC to at least be on the same page that we can have this work started by the end of January.
Senator Mark.
May I ask the Honourable Minister whether his ministry has a time frame for the completion of these surveys, which are so important to address the issues that we have identified?
Thank you, Madam President. My information is that the Arima River would have been completed, and all the surveyors are now surveying the Caroni side of it. And the last meeting I had with them last week, Thursday, they indicated by the end of this week we should have the surveys in hand. However, the surveys will give you the areas. Remember, rebuilding banks is just not as simple as someone may think. There's certain types of clay that you have to use to rebuild the bank. The Ministry of Works are in the process now of evaluating a contract for Centelina all the way down to the Sama Barata River for rebuilding the banks of the Caroni River. That project should have started since 2013. It is now about to be started, and we have decided to actually start from the Centelina area, going all the way back up to the Arima River as an emergency solution. Thank you.
Next question, Senator Dialsing.
Thank you, Madam President. Question number 85 to the Minister of Planning and Development.
Minister of Planning and Development.
Thank you very kindly, Madam President. Thank you for the question. Policies of the Town and Country Planning Division include requirements for community facilities, including recreation and other green spaces. Provisions for both active and passive recreational open spaces must be made in all comprehensively planned developments of over 20 dwelling units. In new residential developments of between 20 to 100 dwelling units, the division requires a minimum of 0.2 hectares per 100 units, or 20 square meters per unit, and this must be allocated for green spaces. For larger residential developments of over 100 dwelling units, a minimum area of 0.4 hectares per 100 units must be allocated for a local recreation ground, parks, and playlots. In multiple family residential developments, developers are required to allocate a portion of the site of the area being developed to be used by residents as communal open space, amenity, and recreational areas. The development of the open space is the responsibility of the developer and should proceed together with the construction of the residential units and facilities. The development of the open space area or a major portion thereof should be completed prior to the occupation of homes within the subdivision, and on completion of the development, the developers have responsibility for maintenance of these open space areas until such time as alternative arrangements are made. The Town and Country Planning Division maintains that developers must design these open spaces as part of any proposed subdivision layout relevant to the required criteria, and these must be shown on the submitted application. Municipal corporations, therefore, cannot or should not grant approval and completion certificates to applications that are forwarded to them until the open spaces are provided and developed as approved by the Town and Country Planning Division. In circumstances where unauthorized built development on approved open space is observed, these matters are handled through the complaint and enforcement process as provided for under Section 16 of the Town and Country Planning Act, Chapter 3501. That is to say, a complaint is made by someone who may observe that the space is not being maintained, and the enforcement unit of the Ministry of the Town and Country Planning Division acts to investigate the complaint and to act on the complaint as immediately as possible. Simultaneously, complaints regarding same can also be lodged with the relevant municipal corporation, which also has responsibility for ensuring that required green spaces are developed and that built development does not occur within them. Thank you, Madam President.
Ramdeen.
Madam President, thank you. Madam President, through you to the Honourable Minister of Planning and Development. Minister, are you satisfied with the manner in which the municipal corporations, together with the Town and Country Planning Division, have been enforcing these regulations that are in place to protect these green spaces in these developments throughout Trinidad and Tobago?
Minister. Thank you very kindly for that question. Madam President, I would not say that I'm completely satisfied, but given the constraints with regard to staffing and the time that it takes for a complaint to be lodged, and also for the enforcement unit to examine the veracity of the complaint, it takes a little longer than we have anticipated. And Madam President, that is why we're before the House today with the planning and facilitation of development amendments.
Senator Ramdeen.
Madam President, through you, Madam President, to the Honourable Minister. Honourable Minister, having regard to the 4-year limitation period that is encompassed into the old Act, that the present Act, which is the Town and Country Planning Act, what steps have been taken by the Ministry to ensure that the compliance and enforcement units of both the Town and Country Planning and the regional corporation are beefed up to ensure that where there is an illegal development taking place or not in accordance with the guideline, that 4-year period doesn't elapse before steps are taken either by the ministry or the regional corporation to protect the interests of the communities where these illegal activities are taking place.
Minister.
Madam President, I would like to indicate that in most instances, that is not a very prevalent occurrence. That is to say, the development of built development on open spaces. It is not a very prevalent occurrence. But where it does occur and a complaint has been made or an officer has observed the development, we have been making extra efforts to ensure that we act within that 4-year period. And I must say that in the recent past, it is clear that the members of staff of the enforcement unit and the municipal corporations have been working assiduously together, and they have been enforcing much more quickly than they had previously. So that issue has been dealt with much more expeditiously than had occurred previously. Thank you.
Senator Mark.
The Honourable Minister, what is the level or extent of staff shortages within the Town and Country Planning Division or within the ministry that is inhibiting the ministry from professionally and urgently reacting and enforcing the legislation?
Minister.
Madam President, I don't have the exact ratio that the member is requesting, but I will say that we have a number of people on contract specifically employed to do enforcement, but it could be a lot more effective if we had a larger staff, because in many instances, citizens of Trinidad and Tobago have not been complying with the law. And as a consequence of that, we have gone on a campaign of enforcement, and that has been working a lot more effectively, so that we have had quite a larger number, a much larger number of enforcement matters being taken to the court, and the court is also understanding the importance of adjudicating on these matters more expeditiously, and that has been working to some extent. But of course, it is not perfect, but the numbers have improved. But I can provide that ratio in writing if you would like.
Senator Ramdeen.
Madam President, through you to the Honourable Minister. Minister, having regard to the answers that you've given, a lot of these cases where, as you've said, people have not been complying with the law as laid down in Town and Country Planning Act, is as a result of some form of corruption, not more so much at the ministry, but more so at the regional corporations where people get things done without the correct approval. What steps have been taken by the ministry to ensure that the internal mechanisms of the ministry and as well as the regional corporation are not subject to that kind of abuse, to ensure that the law is enforced and the citizens of Trinidad and Tobago who are involved in development comply with the law to the benefit of the citizens?
Allow that question, and I will caution members when asking supplementary questions to try and make it as succinct as possible. Next question, Senator Obika.
Thank you very much, Madam President. Question number 87 to the Minister of Finance.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, the Central Bank of Trinidad and Tobago has advised that Scotiabank Trinidad and Tobago Limited is a subsidiary of Scotia Caribbean Holdings Limited, a regional financial holding company based in Barbados. Scotia Caribbean Holdings Limited is itself wholly owned by the Bank of Nova Scotia. The entities that are being sold in Anguilla, Antigua and Barbuda, Dominica, Guyana, St. Kitts and Nevis, St. Vincent and the Grenadines, St. Lucia, St. Martin, and Grenada are either subsidiaries or branches of the Bank of Nova Scotia and not Scotia Caribbean Holdings Limited. Furthermore, Republic Financial Holdings Limited, a Trinidad and Tobago-based company, has entered into an agreement to take over the Nova Scotia banking operations in these territories. This acquisition by a Trinidad and Tobago company is expected to positively impact the Trinidad and Tobago economy. To be clear, Madam President, contrary to the premise on which the question was based, Scotiabank Trinidad and Tobago Limited is not withdrawing from any Caribbean territories. While the Central Bank of Trinidad and Tobago does not currently expect an adverse impact on Scotiabank Trinidad and Tobago of the proposed withdrawals by certain of its affiliates from the Caribbean, the Central Bank will continue to monitor the developments that are taking place at the group level to determine the impact, if any, on Scotiabank Trinidad and Tobago Limited. I thank you, Madam President.
Senator Obika.
Thank you very much. I thank the Honourable Minister for the submission. However, as can the Minister indicate if the Ministry will be doing similar as the Central Bank has, as she has stated that Central Bank will be doing? Sorry.
Minister.
Madam President, as I am sure the Senator is aware, the regulator for financial institutions in Trinidad and Tobago is the Central Bank, and that is the body that is responsible for ensuring the viability and continuity of the members of that sector. I thank you, Madam President.
Senator Obika.
Thank you very much, Madam President. Under the Ministry of Finance, there is the division that relates to the customers of the bank. Has the Minister gotten any feedback from that division?
That question doesn't arise. Any other questions, Senator Obika? Next question, Senator Richards.
Thank you, Madam President. Question number 88 to the Minister of Agriculture, Land and Fisheries.
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam President, and I thank Senator Richards for this question. Madam President, the most important measure taken for the protection of the scarlet ibis is the declaration of the bird as an environmentally sensitive species under the Environmental Management Act by Legal Notice 143 of 2018, published on October 11, 2018. Madam President, other measures include: 1. Programs to educate the public about the protection measures in place for the scarlet ibis and the importance of the ibis to biodiversity, conservation, and economic activity in and around the Caroni Bird Sanctuary. 2. Increase resources directed to law enforcement at the nesting and roosting areas. 3. Increase interagency collaboration and operational activity, particularly with the Coast Guard, the EMA, Zoological Society of Trinidad and Tobago, Ministry of Rural Development and Local Government, Ministry of Tourism, and other community stakeholder groups, including tour operators. 4. Advance work with the UNFAO to strengthen protected areas management system in Trinidad and Tobago and improve capacity building in the Forestry Division and the communities around the Caroni Bird Sanctuary. And 5th, the recent establishment of a management committee for the Caroni Lagoon National Park and Bird Sanctuary. I thank you, Madam President.
Senator Richards.
Minister, can the Minister indicate if through these efforts and others in the Ministry, if there has been an assessment on the populations, the impact on populations of this national treasure?
Minister.
Madam President, all the reports based on observation and based on interaction with the tour operators and other people who are familiar with the Caroni Bird Sanctuary and visits to the nesting areas over the last 2 years point to no significant reduction and possibly an increase in the population of the scarlet ibis. Having said that, Madam President, the work of the poachers and the ability to remove hundreds of birds in one day is always a risk, and that is why we believe that the 100,000 fine and increased enforcement should serve as an appropriate deterrent.
Next question, Senator Deoroop.
Question number 89 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Thanks to the Honourable Senator for the question. A number of projects benefiting fence-line communities are already in train, and others are about to be embarked on. The projects which are targeted for the West, South, and Southwestern Peninsula communities include the following. The San Fernando-Point Fortin Highway, which is already in train and for which construction is being accelerated in this year, 2019. The Labre Dry Docking Facility, NIDCO and China Harbor Engineering Company executed a cooperation agreement for the development of the facility over a 3-year period at a cost of US $500 million. The construction activity associated with this project will include a deepwater channel excavation, offshore reclamation, and terminal land construction. The construction of the jacket by TOFCO in Labre of BP's Cassia Field Development Platform, that's the next big BP project, and we are pleased to announce that we have brought back fabrication to Labre. Phoenix Park Industrial Estate, Beijing Construction Engineering Group Company Limited, BCEG, and the Evolving Technologies and Enterprise Development Company, ETEC, have executed a memorandum of understanding for the development of the Phoenix Park Industrial Estate, Point Lisas, at a cost of US $104 million. The San Fernando Waterfront Redevelopment and Regeneration Project, modernizing the Kings Wharf Central and South Node at an initial cost of $144 million TT. The development of an administrative complex at Chancery Lane, San Fernando, and the restoration and upgrading of Skinner Park. A new fishing port in Moruga and associated facilities included a modern fishing facility and an offshore component consisting of berthing and landing facility. And finally, the rehabilitation of the Moruga Road itself from Pitikafe Junction straight on to Marak, for those of you who know the Deep South. If required, counseling services will be provided. However, more appropriately, there will be community engagement to ensure that members avail themselves to the opportunities. It is estimated that 3,500 direct jobs and 5,700 indirect jobs will be created in the Southwestern Peninsula. Employment data on other projects will be made available when determined.
Madam President, can I ask through you to the Honourable Minister, when will the Labre Dry Dock construction commence? When will construction commence at the Labre Dry Dock? Minister.
As I have said, Madam President, memorandum of understanding of cooperation agreement has been signed. It will now move on to direct negotiation. As the Prime Minister said on his return from China, it is the first time in Chinese direct equity investment will be made available outside of China. China's model for development had always been for Chinese contractors to get work. The President of China was convinced by the Prime Minister of Trinidad that China Harbor will have a 30% equity in the Labre facility. And we hope that construction should begin in the latter part of this year.
Senator Ramdeen.
Thank you very much. Madam President, through you to the Honourable Minister. Honourable Minister, when can we expect this engagement that you have said is going to come with, to engage the 5,322 workers and the 8,000 indirect workers that have been now rendered unemployed by the decision of your government to close
Senator
the
Ramdeen. All right. Senator Ramdeen, please try and it's a question arising from the answer. It needs to be a little tighter, okay? Minister. Minister.
Madam President, the projects are ongoing. Some are advanced. The highway construction to Point Fortin is already there. It is employing more and more people. TOFCO has already started the fabrication of the Cassia jacket. When the dry docking facilities, which is a mega project. Remember, this is Panamax type vessel coming for dry docking facilities in Trinidad. China has the largest merchant marine fleet in the world. China is the biggest people in trade. China's vessels virtually monopolize the Panama Canal. America is big in IT. The big American companies are Google and Facebook and Amazon. China deals with ships and actual trade in goods more than in services. So it is an ideal opportunity for Trinidad and Tobago to engage in a Chinese company, which for the first time in its history is taking equity in a project. As a thing from telling you, come to the Chinese bank, we'll lend you money, and take our contractors because we lend you the money. It is a whole new business model that has its genesis in Trinidad and Tobago, thanks to the Prime Minister of Trinidad and Tobago.
Honourable Senators, the time for answering questions has expired, and I would ask members who are ministers who were due to answer questions to have a look at Standing Order 27, sub 12. Minister, Leader of Government, Ms.
Move to urgent questions, please.
Sure. Honourable Senators, at this stage, we will now revert to the earlier proceedings to deal with urgent questions. Senator Mark.
Thank you, Madam President. To the Minister of National Security. In light of reports that the police service is unable to procure critical goods and services because of a lack of funds, can the minister indicate when this situation will be rectified?
Minister of National Security.
Thank you very much, Madam President, and thank you for the indulgence of allowing me some time to get here to answer urgent questions. As has been stated by the Minister of Finance, the Minister of Finance has been consulted. He had a request from the Trinidad and Tobago Police Service, in particular the Commissioner of Police, for a certain sum of money. I think it was about $80 million. $20 million has been released. Another $20 million was supposed to be released today. Another $20 million will be released at the end of the month, and then the further 20 next month. So the monies have been now, half of the money has been released, with the rest to come.
Senator Mark.
Madam President, can the minister share with us whether the shortages or the short supply of funding to the police service is having a negative impact on their operations? Can you share with this House what impact, if any, this situation is having on the operations of the service?
Senator Mark, I won't allow that question. You have one more that you can ask.
Can I ask the minister whether the report that we have been privy to on the public, that the police K9 unit, as well as the mountain branch, are unable to buy critical ingredients for those animals in their care because of the shortfall in funding? Can you share any light on this matter, whether there's any truth in this matter?
Senator Mark, that question does not arise. Next question, Senator Mark.
To the Minister of National Security. In light of recent reports that criminals are in possession of Trinidad and Tobago Police Service ammunition, what measures are being taken to address this situation?
Minister of National Security.
Thank you very much, Madam President. Madam President, as has been quite publicly stated by the Commissioner of Police, immediately upon learning of this arising, that is that certain unauthorized persons seem to be in possession of Trinidad and Tobago Police Service ammunition, the Commissioner of Police has ordered an audit be done of the arms and ammunition in the police service.
Madam President, in light of the urgency of this matter involving a citizen being murdered by bullets from the police service, by bandits, can the Minister share with his House what is the time frame for this audit of arms and ammunition so that the perpetrators of this crime can be brought to justice?
Minister of National Security.
Thank you very much, Madam President. Madam President, those are two very different occasions, i.e. the perpetrators being brought to justice. They are currently being pursued, and I think the police are actively investigating it, and they've been having quite an increase and an uptake in the detection of perpetrators within recent times. In fact, we saw those who had committed the act of robbery at the South Plaza in South recently have been held and were taken before the court. With respect to the conduct of the audit, again, this is something that is completely within the purview and the ambit of the Trinidad and Tobago Police Service, and in particular the Commissioner. And he did indicate to the public that there is a level of urgency with which this audit has to be conducted, and I am sure he will press them to have it completed in the shortest possible time frame.
Senator Mark.
Madam President, can I ask the Honourable Minister, what, if any, immediate measures have been taken to avoid bullets and ammunition and arms from the police service from getting into the hands of bandits and criminals? What immediate steps, while the audit is being conducted, are being taken to avoid a repetition of what has happened, Madam President?
Minister of National Security.
The proper securing of arms and ammunition owned by the Trinidad and Tobago Police Service.
So they won't Madam, I think I have exhausted.
You have.
Request for leave to move the adjournment of the Senate on definite matters of urgent public importance.
Senator Haynes.
Thank you, Madam President. I hereby secure leave to move the adjournment of the Senate today under Standing Order 16 to discuss a definite matter of urgent public importance, namely the failure of the government to adequately inform the nation of the public health crisis facing Trinidad and Tobago, that is, the H1N1 swine flu outbreak. The matter is definite because it deals specifically with, in light of a significant number of confirmed cases of this virus, and a poor attempt by the government to disseminate critical information to the public as to what measures are being taken to mitigate the risk posed to citizens. The matter is urgent because it was only after 3 recorded deaths from the H1N1 virus that the Minister of Health publicly described the situation in South Trinidad as a crisis. The matter is also urgent as there are now more widespread reports of persons being infected. The matter is of public importance because the public must be informed of the severity of this escalating public health crisis and what measures are being taken to effectively stop the spread of the virus.
Honourable Senators, I have considered the motion, but I am not satisfied that this matter qualifies under this standing order.
Motions relating to the business or sittings of the Senate and moved by a minister.
Leader of Government Business.
Thank you very much, Madam President. Madam President, having regard to the interim report of the Joint Select Committee appointed to consider and report on the Cybercrime Bill 2017, I beg to move that the committee be granted an extension to May 31st, 2019 to complete its work and submit a final report.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the Cybercrime Bill 2017 be granted an extension to May 31st, 2019 to complete its work and submit a final report. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Leader of Government Business.
Thank you, Madam President. Madam President, having regard to the interim report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016, I beg to move that the committee be granted an extension to May 31st, 2019 to complete its work and submit a final report.
Senators, the question is that the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016 be granted an extension to May 31st, 2019 to complete its work and submit a final report. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Public Business, Government Business Bill, second reading.
Minister of Planning and Development.
Thank you very kindly, Madam President. Madam President, I beg to move that a bill entitled An Act to Amend the Planning and Facilitation of Development Act 2014 and to consequentially amend the Environmental Management Act, Chapter 3505, be now read a second time. Madam President, before I start, I crave your indulgence to request that I be allowed under Standing Order 4211 to read from my notes. Thank you very much. But that is why there's a standing order, so I'm invoking it.
And she's a tough debater.
Thank you very kindly, Madam Speaker, Madam President. Madam President, the bill before us is as a consequence of amendments to the Planning and Facilitation of Development Amendment Bill. And this bill also, as I indicated at the outset, will consequentially amend the Environmental Management Act, Chapter 3505. Madam President, I would like to indicate that the reasons for the amendments are that whilst we of the People's National Movement were in opposition when the Planning and Facilitation of Development Act was passed, there were a number of issues for which we had grave concern. As a consequence of that, on July 18, 2016, the Minister of Planning and Development established a committee to review the Planning and Facilitation of Development Act, and this committee was chaired by Dr. James Armstrong. The objective of this committee was to ascertain whether the Act could be fully proclaimed in its existing form. The committee submitted its recommendations in September 2016, and the Ministry of Planning and Development continued to review the legislation with a focus to ensuring that the legislation could be operationalized. The review, therefore, has resulted in the amendments which are being presented here today. One notable disquiet, Madam President, that we had whilst in opposition and we had when we came into government was the issue of the qualifications for the Director of Planning, which we saw as a key position within the planning framework. We felt that the qualifications were vague at best, and therefore, if not amended, an unsuitable person could have been appointed to this position and not be eligible or recognized by the planning fraternity as being suitably qualified. And Madam President, may I indicate that that particular section of the Act was one of the sections that was proclaimed, because in this particular Act, it is by proclamation, and certain sections have already been proclaimed. What we felt, though, was that the qualifications for the Director of Planning were very vague, very limited, in that it said, and I wish to quote what those qualifications were or are, and it says in the Act that the person who would be the Director of Planning must have qualifications and a certain number of years of experience. And Madam President, what we felt was that qualifications was very vague, very wide, and did not specify the specific qualifications necessary for someone who would be the holder of such an important position in Trinidad and Tobago. And consequently, that is one of the main amendments that we are presenting here today. In addition to that, there was also a concern that that particular part of the legislation appeared to be ad hominem, in that it was to allow a particular person to qualify for the position of director. Additionally, Madam President, there was an even more major concern in that the qualifications that are in the accompanying bill, which is a bill that will be before the House for the position of urban and regional planners, the qualifications that were in the Act did not meet the necessary qualifications for such a person to qualify as an urban and regional planner in accordance with the legislation. And so we felt that it was imperative that this particular clause be brought before the Parliament to be amended. Madam President, we also had concerns as to how the regional corporations, which were now being constituted as planning authorities under the Planning and Facilitation of Development Act, were going to be able to carry out the task of planning that was being placed upon them. Indeed, I'm happy to report that this government understood that the only way to equip these regional bodies with the capacity required to undertake this planning portfolio was through local government reform, and we continue to assiduously pursue this agenda. Finally, Madam President, it is important that further amendments be made, in that even though these amendments are small, they are in no way minor, as they will enhance the legislation to the point of making the Planning and Facilitation of Development Act workable. Madam President, I would like to do a quick recap of the objectives and purpose of the Planning and Facilitation of Development Act. This act was passed on October 1st, 2014, and its objective is to repeal and replace the Town and Country Planning Act upon its full proclamation. It seeks to reform the planning laws of Trinidad and Tobago by establishing, 1, a system for the preparation and approval of national and subnational development plans, and 2, a system of planning and development approvals which are designed to secure predictability, simplicity, promptness, and transparency in the treatment of development applications. To achieve these objectives, therefore, the Act provides for the establishment of a National Physical Planning Authority that will collaborate with the Environmental Management Authority and other institutions to safeguard the preservation of the environment as an integral part of the planning process. The Act also provides, amongst other things, for the devolution of certain decision-making powers relating to development control, amongst other things, to local government through the creation of municipal planning authorities at the local government level. These planning authorities and the Tobago House of Assembly will collectively be called planning authorities. Madam President, the Planning and Facilitation of Development Act, as I said before, was partially proclaimed by legal notice number 151 of 2015. This partial proclamation allowed mainly for the establishment of and appointment of members of the National Planning Authority and the hiring of staff accordingly. To execute this mandate, PricewaterhouseCoopers was formally retained in July 2015 to do three things in the main. One, design the organizational structure of the national planning authorities, that is to say, job descriptions, job positions, and grades within the overall context for the administration of the new system to be established. Two, conduct an executive search and assist in the recruitment and selection of persons to fill the key positions of Chief Executive Officer, Corporate Secretary, Director of Planning, Chief Building Officer, and Chief Enforcement Officer. And three, provide strategic recommendations on the salary structure to be established. Madam President, as at September 2015, when the new administration took office, 2 deliverables had been completed and paid for before the consultancy was ended. The 2 deliverables were 1, the inception report, and 2, the preparation of a draft value chain for the NPA, that is to say the National Planning Authority, and also a proposal for comparator organizations for compensation survey. Draft job descriptions were also completed, and there was a preparation of an advertisement inviting applications for executive staff. The consultancy lapsed when a review of the Act was instituted in 2016. Madam President, in 2018 August, it was agreed that the Act implementation would proceed, and consequently, PricewaterhouseCoopers was re-engaged, and this was done at a cost of $339,000. And this was an adjustment to the original cost of the consultancy, which was $351,258. Madam President, at this time, the consultancy will be completed within the next month, and we are anticipating that by February of this year, we should have all that the contract requested. Madam President, having provided this brief summary of what has happened thus far, allow me now to present the bill that is before this House. As I said initially, there are 14 clauses before the House, and the short title and the interpretation are before us for amendment. And clause 3, Madam President, is the insertion of a definition of the term simple development. Simple development would be inserted after the definition of the word road, and simple development, we felt, was not previously defined in the Act. The matters defined as simple development would be consistent with those matters that would mainly comprise simple development applications. Complex development would impliedly be those developments which do not fall within the definition of simple development. Applications relating to simple development will all be determined at the level of the planning authorities. That is to say, the municipal corporations and the Tobago House of Assembly. The proposed definition, therefore, of simple development is as follows. Simple development means development for which an application is made for A, billboards or advertising signs, B, outline or final planning permission not requiring a certificate of environmental clearance, C, change of use, residential or building developments or any additions thereto, where the cumulative floor area with additions, if any, does not exceed a gross floor area of 500 meters squared. D, land subdivisions, including engineering operations, comprising less than 20 plots, provided that each plot falls within the range of 465 meters squared and 800 meters squared inclusive. Clause 4. This is an amendment to Section 11, which is the removal and replacement of certain representatives on the Development Control Committee. Madam President, the Development Control Committee will consider complex applications with national significance as is referred to it by the Director of Planning or the Chief Building Officer. Madam President, upon review of the Act, it was recommended that a representative from the municipal or regional corporations and a representative from the line ministry with responsibility for physical planning be included on the Development Control Committee. The municipal or regional corporations would have jurisdiction over simple applications, but will have to pass all complex matters that came before them to the National Planning Authority. They should therefore be present for the deliberations of such matters by the committee. The representative, it is clear, must be technically sound. Clause 4 of the bill, therefore, amends Section 11(2)(b) of the Act to include representatives from the Trinidad and Tobago Association of Local Government Authorities and the ministry with responsibility for physical planning and development of land, and remove from the Development Control Committee representatives from the Occupational Safety and Health Agency and the Chief Medical Officer in the ministry with responsibility for health. Madam President, may I indicate at this point that the Chief Medical Officer can be co-opted, but will not be a sitting member of the committee. Additionally, because of the fact that the Occupational Safety and Health Agency is a determining agency as it relates to the safety issues in built development in particular, we felt it was not necessary for such an officer to sit permanently on the committee, but such an officer could be co-opted if it was necessary. And as a consequence of this, we have removed those two positions and inserted instead a representative from TALGA, which is the Local Government Authorities, the Association of Local Government Authorities, and the ministry, which would be the Ministry of Planning and Development. Clause 5 is an amendment to Section 13 of the Act, and that is in relation to the qualifications of the Director of Planning and post-qualification experience of the Director of Planning, the Chief Building Officer, and the Chief Enforcement Officer. Madam President, Clause 5 amends Section 13(2) of the Act by providing additional qualifications for a person employed as the Director of Planning, by also specifying the type of engineering post-qualification experience required for the Chief Building Officer, and by revising the post-qualification experience required for the Director of Planning, the Chief Building Officer, and the Chief Enforcement Officer. Madam President, we were of the firm view that the qualifications of the Director of Planning needed to be raised. This was imperative because it needed to be consistent with the requirements of eligibility to register as an urban and regional planner under the proposed Urban and Regional Planning Bill. Madam President, it was clear that the Director of Planning could not be a person who could not obtain registration under the Urban and Regional Planning Bill that is proposed and that will find itself within this act, which we are now amending. It was farcical, we felt, that the Director of Planning, who would be the Chief Planner, in other words, for Trinidad and Tobago, had qualifications or was supposed to have qualifications which did not meet even the barest minimum qualifications to be registered as a planner. This was totally farcical, Madam President. We were flabbergasted that this was the part of the act that was proclaimed. And it is clear, Madam President, that it made no operational sense. And consequently, we are before the Senate today to ensure that this amendment finds favor with the Senate. And so, Madam President, I repeat, the qualifications of the Director of Planning needed to be raised to be consistent with the requirements of eligibility to register as an urban and regional planner as proposed under the Urban and Regional Planning Bill. Failing this, Madam President, the Director of Planning could not be considered as a listed professional in accordance with Part 7 of the Act. And Madam President, the Act specified that only listed professionals could approve plans. So it was totally farcical. Madam President, I repeat that the current requirement for Director of Planning in the Act is, and I quote, qualifications without more. That's not part of the Act, but it's qualifications and at least 10 years post-qualification experience in urban and regional planning. End of quote. Madam President, I repeat, these qualifications are quite vague and do not point to the significant competence required of a person who, as Director of Planning, would be responsible for development planning and development control. What we are proposing now is that the qualifications of the Director of Planning should be as follows. The Director of Planning, who shall have 1, an undergraduate degree in the field of urban and regional planning and a postgraduate qualification in urban and regional planning or a related field, and 2, an undergraduate degree in a social, environmental, or design science, and a postgraduate degree in urban and regional planning. Madam President, the post-qualification experience of the 3 positions of Director of Planning, Chief Building Officer, and the Chief Enforcement Officer are also to be amended, and it has been revised from 10 years to 7 years to make it easier to fill the post. But, Madam President, a concern has been raised with regard to the issue of moving from 10 years to 7 years. But what we had found when the review was undertaken by PricewaterhouseCoopers was that that 10-year capability was not readily available in Trinidad and Tobago. However, the degree was very available. The undergraduate degree, the postgraduate qualifications, and the experience was more in line with 7 years rather than 10 years. And as a consequence of that, Madam President, we felt these were the amendments that needed to be made specifically with regard to the Director of Planning and the Chief Building Officer and the Chief Enforcement Officer. Madam President, Clause 6 repeals and replaces subsections 2 and 3 of Section 15, and it relates specifically to the functions of the Chief Building Officer and the Chief Enforcement Officer. This clause clarifies the functions of the Chief Building Officer and the Chief Enforcement Officer by repealing and replacing subsections 2 and 3 and substituting the following subsections. The Chief Building Officer shall establish inspection procedures for building and engineering operations, forward breaches of planning regulations referred to him from the National Planning Authority or a municipal or regional planning authority to the Chief Enforcement Officer, and perform certain functions as specified in the Act in sections 62, 66, 67, 68, and 70. And the Chief Enforcement Officer shall take action against breaches of building regulations referred to him by the Chief Building Officer and breaches of planning control referred to him by the Director of Planning. Madam President, one of the issues that even today has been raised is the issue of enforcement. And the Act strives to ensure that enforcement takes place at a much faster level, at a much faster pace. And consequently, we felt it was imperative that both the Chief Engineer or the Chief Building Officer and the Chief Enforcement Officer had to have specific capability and specific requirements that would ensure that they did their job expeditiously. Hence these amendments. Madam President, Clause 7 repeals subsection 4 of Section 31. And this provision, we felt, is no longer necessary because it is already provided for under subsection 3 that development allowed by a development order would be subject to such conditions and limitations as may be specified by the order. With regard to Clause 8, this would amend Section 60 of the Act by providing a person with the right to appeal to the Environmental Commission against a tree preservation order. Madam President, in the Act itself, there was no right of appeal against such an order. A tree preservation order, Madam President, is an order against cutting down a tree or removing a tree. It's very similar to what occurs now in the more developed countries, but we felt it was imperative that there should be a right of appeal, and that appeal should be to the Environmental Commission. Hence the overlap between this legislation and the Environmental Act. Clause 9 would amend Section 73 of the Act by deleting the definition of simple development application, because under Clause 3 of the bill, we have inserted the new definition. Madam President, this clause would also amend paragraph D in the definition of professional governing body, in that the governing body under the proposed Urban and Regional Planning Profession Act was not mentioned. That is the Trinidad and Tobago Council for Urban and Regional Planning, and that was an oversight. Madam President, Clause 10 amends Section 89 of the Act by providing the Environmental Commission with the power to exercise jurisdiction over appeals of decisions made by any planning authority. That is to say, the National Planning Authority or the municipal or regional planning authorities. And the reference to planning authorities was inadvertently left out in this section. And the planning authorities are those authorities which make all decisions except those related to complex matters. And appeals would also, therefore, arise from those decisions. Clause 11 amends Section 90. And this was generally a clause to tidy up the legislation, as Clause 11 would amend Section 90 of the Act in subsection 3C1 by inserting after the words planning control the words or have been complied with. Madam President, it was clear that there were certain things that needed to be put in place. Simple, as I said, they may seem simple, but they were not minor. Because if these simple amendments were not made, the Act could not be effective. Clause 12 repeals subsection 1G and H of section 95, and that relates specifically to the offenses. And we were of the view that these provisions are not necessary because failure to comply with the requirements of any compliance notice or compliance order or development repair order is already extensively addressed under sections 54 and 57 of the Act. Consequently, it just seemed repetitious and unnecessary, and we felt we needed to remove those. Madam President, Clause 13 amends the first schedule, and these amendments provide inter alia for the appointment of a Chief Executive Officer of the National Planning Authority, secondment of officers to the service of the National Planning Authority, and extends the period of the exercise of options available to public officers upon the full proclamation of the Act from 3 months to 6 months. And I know that Senator Mark will be very happy about this, as is Senator Baptiste Primus, because it is imperative that we give officers enough time to make that decision and to have it done effectively. So the first schedule of the Act is amended in Clause 1, in subclause 1BV, by deleting the words sectoral interests and substituting the words sectoral private interests, and by inserting after subclause 3 the following subclause. 3A, the National Planning Authority shall appoint a Chief Executive Officer who shall be an ex officio member and be responsible for the day-to-day management of the National Planning Authority. So the CEO is an ex officio member of the National Planning Authority. And as I said before, deleting the words 3 months and substituting the words 6 months, because it is a more practical time frame for the exercise of those options. Also, by deleting paragraph B and substituting the following paragraph, and that is, these officers be employed with the National Planning Authority on terms and conditions no less favorable than those enjoyed by him in the public service, and also, Madam President, we felt that the Public Service Commission indicated to the ministry that it has no power to transfer persons out of this service and into an independent organization. And the Public Service Commission can merely note the movement from the service into the independent organization. Therefore, it was necessary to remove the words with the approval of the Public Service Commission. And the amendment goes further by deleting the words date of the assent of this Act and substituting the words date of commencement of this Act. And that is in keeping with the fact that this Act requires proclamation. Madam President, after clause 14, we will be inserting the following words, and that is an officer, that is 14A1, an officer or employee in the public service, a statutory authority, any domestic or foreign public or private body may, with the consent of the National Planning Authority and the approval of the appropriate service commission or relevant body, consent to be transferred on secondment to the service of the National Planning Authority. And 2, where a transfer on secondment is effected, such arrangements as may be necessary shall be made to preserve the rights of the officer or employee transferred to any pension, gratuity, or other allowance for which he would have been eligible had he not been transferred. Madam President, clause 14 is, as the as I indicated from the outset, the consequential amendment to the Environmental Management Act. And this clause provides for the members of the Environmental Commission to be expanded to also have members who have knowledge of or experience in urban and regional planning. Madam President, this clause also increased the complement of persons on the Commission by 1 person to facilitate the new inclusion of urban and regional planner as a member. Madam President, it would have been farcical for us to have the Environmental Commission not have someone with that specific qualification sit on the Commission, because it is clear that there will be matters coming to the Commission which had not come to the Commission before, and consequently we felt that that specific qualification was necessary to be part of the Commission. Madam President, as I said, essentially those are the clauses that are before this House for debate and approval. And Madam President, I would like to give the assurance that the objective is, upon agreement in this House, to ensure that this act is proclaimed in the shortest possible time. And Madam President, as a consequence of that desire, the Ministry of Planning and Development has been working assiduously at ensuring that everything is being put in place to ensure that when the act is passed, when these amendments are passed and become law, there will be enough time to ensure that everything is in place and there is no further delay as it relates to the Planning and Facilitation of Development Act. Because, as I said, it is an act that comes into effect by proclamation, and the ministry has been making every effort to ensure that it can be operationalized immediately upon approval by the Parliament of Trinidad and Tobago. Madam President, may I also draw to the attention of this Senate that in the meantime, the Ministry of Planning and Development has started the transformation of the construction permitting system in conjunction with the Ministry of Rural Development and Local Government. Madam President, this transformation of the construction permitting system is the automation of the application process to an online one-stop shop for planning and building permits. It is also the conversion of historic development application files and map records into a digital form, and the improvement of service delivery at the Town and Country Planning Division. Madam President, these projects will deliver a modernized, re-engineered construction permitting system which removes many of the complications and redundancies in the present process and provides 24/7 access to services and better connects applicants to the permitting agencies. At the same time, we are making historical records more easily available to staff involved in the day-to-day processes by digitizing existing records. Additionally, these improvements are coupled with initiatives to provide training to staff to improve the physical workspaces and increase the level of information on policies and procedures available to the public. These improvements will be visible as the automated system will be launched in the first quarter of 2019. These improvements will also benefit the regional corporations who will now have access to an integrated online system and digital data to enable them to execute their mandate and ensure that the time limit for producing approvals is cut drastically. Madam President, how much more time do I have?
Minister, you have 5 more minutes.
Thank you very much, Madam President. Madam President, I just wanted to also indicate that there is also progress in the ministry as it relates to policy development. The hillside development policy has been completed. The planning policy for mobile telecommunications has also been completed. The advertisement policy review has been completed. The Port of Spain land use policy, that is the formation based on codes. The first phase has been completed and there is a draft. The Southwest Tobago policy review is in progress. The microspatial policy review is an ongoing exercise, and that relates to specific areas throughout the country where there is need to change the policy. There is also an update and review of land use policy maps for all regions. The Aranguez North Local Area Policy Review is ongoing. And the spatial planning guidelines, there are 12 spatial planning guidelines which have been approved, and an additional 18 are being developed. And there is also the standardization of outline planning permission. In many instances, Madam President, members of the public are of the view that it seems as though they do not have a standardized system for putting in their documents and determining what the development should look like. And so the Town and Country Planning Division has been on a program of standardizing outline planning permission and making it much easier for the citizens of Trinidad and Tobago. Madam President, I am of the firm view that there should be no disquiet amongst the members of this Honorable House in terms of the amendments which are before you for consideration and for approval. And Madam President, I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Planning and Facilitation of Development Act 2014 and to consequentially amend the Environmental Management Act, Chapter 3505, be now read a second time. Senator Mark.
Thank you very much. Madam President, I'm very happy to contribute to this bill entitled An Act to Amend the Planning and Facilitation of Development Act 2014, and to also amend the Environmental Management Act. I listened very carefully to my honorable colleague, the Minister of Planning and Development, in her presentation. And I want to say from the outset that development, I may want to say orderly and sustained development, requires a coherent and well thought out national physical planning framework. If a society is to engage in the kind of positive transformation that is required, that national physical planning framework must be legally rooted and statutorily enforced. And Madam President, I want to say from the very outset that the only national physical development plan that I know of that is legally enforceable was dated 1984. and is the only one that currently is in existence outside one that was presented by the Shagaramas Development Authority. So we have been engaged as a society, as a nation, in what is called ad hoc development, where there's no linkages to the overall physical national development plan for our nation. And therefore, when this legislation was introduced and passed in 2014, as the Honorable Minister said, it followed a journey that began way back in the 80s under the NAR, when John Humphrey was part of that arrangement, followed by the United National Congress under the former Prime Minister, when John Humphrey again was able to conceptualize a national physical planning framework for our country. And then, Madam President, what happened, as usual, development planning and conceptual designs aimed at transforming and effecting a modern developmental approach came to a screeching halt in 2010. From 2001 to 2010, the PNM put a halt to that whole process, claiming, Madam President, that they were concentrating on local government reform. Well, we are still concentrating on local government reform as we speak today. So, Madam President, I would have liked to ask the Honourable Member, the Honourable Minister rather, in this debate, what kind of consultation went into this amendment to the legislation that we are currently debating? Because I remember, Madam President, that when this bill, which was then an Act number 1 of 2014, when that came into effect, the Planning and Facilitation of Development Act of 2014, there was widespread consultation. The country was involved in this whole process. So I wanted to ask the Honourable Minister, in making these amendments, Madam President, to the Parent Act, what was the level of consultation that the country engaged in? Or was it just a report coming from a committee and the minister 2 years after? Madam President, we were told that the report was submitted in September of 2016. We are now in 2019, and we get some spurious, limited amendments to our bill, which if you had effected and operationalized, there would have been a better development process in our country. And Madam President, the chaos that has visited our country would have been significantly reduced if we had effected that measure in terms of operationalizing this law. Madam President, I was waiting patiently on the Honourable Minister to indicate to this House what were the specific objections to the Planning and Facilitation of Development Act that the then PNM had problems with. What were the concerns? What were the areas of the Act that the then opposition had objection to? I didn't hear that, because, Madam President, I read the contributions of the Honourable Minister, who was then a senator, and I saw no objection as what is being proposed here today. In fact, Madam President, the then opposition in the Senate called for a special select committee to deal with this bill that was introduced by the then Minister of Planning and Sustainable Development. And Madam President, it went to a select committee and it was brought back and the entire report was adopted almost unanimously. Nobody objected. So I don't know, Madam President, what was this concern? What were these concerns that we are being told and being advanced to us today? When at the time, materially speaking, there was no objection, Madam President. I didn't read any. I remember when it went to the other place, Madam President, the now Minister of Finance objected, and he did talk about qualifications. And you know, Madam President, what happened? The Senate PNM voted for the bill, but the PNM in the House of Representatives voted against it. So there were two PNM in action in the Parliament at that time, Madam President. That is what went on. So, Madam President, I was really interested in hearing from the Honourable Minister what special objections they had then and what was the rationale for those objections, because I'm not really seeing them. And, Madam President, I want to also say that we have to be very careful in making statements without the evidential backing. When you make a statement, as the Honourable Minister made today, which is disturbing and dangerous, that legislation before us today and legislation, Madam President, that was brought by the then Minister of Planning and Sustainable Development was designed specifically to suit a particular person. And the minister just makes that statement arbitrarily, whimsically, and there is no backing, there's no evidence for what the minister has said. But she has impugned the character of those persons who are not here, as you would advise me, to defend themselves. But we are told this by the Honourable Minister. Ad hominem? Ad hominem. Ad hominem, yeah, legislation. That's what we were told. So, Madam President, I wanted to bring these opening points to your attention because this is our legislation. And all I'm hearing from the minister is that the government will do everything in its power to implement and operationalize this legislation so it could be properly implemented shortly. But I heard that song already being sung. I know about the procurement legislation, Madam President, that we were told would be operationalized, and it is now almost 4 years, and we are still waiting for the operationalization of the procurement legislation. So we are now being told here, Madam President, our act became law on October the 1st, 2014. We are now in 2015, the 15th, I understand, of January. And we have been told by the Honourable Minister, support this legislation, it will be operationalized. Madam President, what I'm saying at this time, what assurances do we have from this government that anything will be operationalized? The government is interested in operationalizing this law? Why did it take the Minister of Planning and Development 2 years to bring these simple amendments, right, Madam President, to this Parliament? Madam President, there are some areas that we are concerned about in this legislation. And I would like the Minister to explain to this Parliament. There are some simple amendments, very, it wouldn't cause any delay or detention. But I didn't hear or appreciate from the minister why this amendment, Madam President, was being advanced. And I'm talking about, Madam President, in clause 4, we advised that section 11(2)(b) of the Act is amended. And Madam President, when you go to the parent act of section 11(2)(b), you will see the section that is being proposed for amendment, Madam President. And we are talking about some development control committee, and it is comprised of a number of representatives. And one of the representatives, Madam President, comes from the Occupational Safety and Health Agency, and the other one comes from the Chief Medical Officer in the Ministry with responsibility for health. These are two very important positions on this committee called the Development Control Committee. The minister, without offering, I haven't heard, and maybe I was outside at the time, Madam President, when the minister was speaking, so if I'm wrong, she will guide me, the Honorable Minister, that is. But I didn't get from the Honorable Minister a proper rationale for the government's decision to delete and to remove a representative from the Occupational Safety and Health Agency, from the Development Control Committee, nor did I hear why we must remove the Chief Medical Officer in the Ministry with responsibility for health. Now, Madam President, we are talking about development, and we are talking about a control and control. And we are saying that this planning committee, the National Planning Authority, has serious responsibilities. So why would we want to water down, reduce the level of representation on this committee by removing these two important agencies or representatives, Madam President? But, Madam President, what is even more shocking is the proposed replacements. We are asked in this Parliament to remove two important representatives, and we are being asked, Madam President, to replace these representatives by who? In the law, in the amendment that we have before us. The Trinidad and Tobago Association of Local Government Authorities. We are asked, Madam President, that a representative from that body must now replace the OSHA representative on that Development Control Committee. We go further. The Ministry with responsibility for physical planning and development of land is also going to have a representative. But I thought the Ministry with responsibility for physical development and planning is the Ministry of Planning and Development. And the minister has already a lot of power under this act. Why would the minister want more power by putting a representative on that particular body, the Development Control Body? And you know that the Development Control Body approves plans, both outline plans and final plans. So the minister wants, so no explanation offered to satisfy us as to why you're putting a local government person on that body. What is the reason? What added value are we going to get here, Madam President? So I'm asking the Honorable Minister to reconsider this position. Isn't this a watering down of the legislation, Madam President? Why would you remove us, Occupational Safety and Health representative, and a representative from the Ministry of Health, and this time the Chief Medical Officer And Madam President, you know that if you are submitting a plan for approval, whether it's for housing or for commercial purposes or industrial purposes or land use purposes, there are health and safety issues involved in these things. Why do you want to remove the health representative? Why do you want to remove this health and safety representative? Madam President, I want to ask the Honorable Minister to reconsider this position, because to me and to us on this side, it doesn't make sense. You put in a local government representative. What are the skills of that local government representative? In fact, the Honorable Minister just sought to convince us that the reason why the government is seeking to increase the qualification and make it more specific for the Director of Planning is because it was too vague in the original act. And the government wants to make it more specific. In this instance, you appointed, Madam President, a representative of the local government body. What is that, Madam President? The majority of persons who form local government and end up forming this executive committee to run this body would be the party that wins the majority of local government seats. So what does that mean? What does that say? It means to say that the PNM or the UNC, whoever has the majority in the council, will now have a politician represented on this body to replace who, Madam President? A professional, occupational, and health representative and the chief medical officer. Tell me what a local government councillor know about health in the context of a chief health, a chief medical officer. Can a local government councillor equate with a chief medical officer, Madam President? And you take it away, as I said. So I don't want to have made the point. So it is an area, Madam President, we would like the government to consider, because we do not support that. Because I was inclined to think before the announcement was made today that Sandal has pulled out of this country. I was about to say, Madam President, whether this legislation is designed for sandals. That is what I was about to say. But events have overtaken my submission. So, Madam President, that is an area, as I said, we are concerned about. Now, the question about qualifications, Madam President, that deals with, if you go to clause 5, you will see where the minister is proposing that the Director of Planning, they deal with an undergraduate degree in the field of urban and regional planning and a postgraduate, and goes on. Madam President, I do not know if what is being proposed, in fact, the minister, a Freudian slip of the lips, indicated that it would make recruitment easier, or would make it easier to recruit people. So you're watering down the brandy, Madam President, in order to fit whatever you have out there. That is the impression one gets from what is being advanced. So, Madam President, why would we want to reduce the period in terms of experience from 10 to 7 years? Again, Madam President, I do not support the argument advanced by the Honorable Minister as to the rationale for this decision. And it's not only the Director of Planning, it is also, Madam President, the Chief Enforcement Officer, and I also believe it is also the Chief Building Officer. these are the three pillars responsible for the execution of policy and programs and major decisions at the level of the National Planning Authority, Madam President. And these are the three positions that have been advanced in this legislation for revision, both in terms of qualifications and the years of experience being reduced from 10 to 7 years, Madam President. And what is even worse, Madam President, is that when you look at what is being proposed here, Madam President, the chief building officer, or let's say the chief enforcement officer, has certain functions, Madam President, in the legislation, and we see where the government is seeking to remove certain functions. So let's go to the legislation, Madam President, and see what the government is proposing as it relates to the chief building officer as well as the chief enforcement officer. Madam President, as I see it here, the government is proposing that we delete from this office, that is the chief building officer, the following functions. I believe that what is being proposed is that we delete under section 15 of the law, subsection 2, C, and D, Madam President, of the legislation. And we would like to know, these are functions that are currently, or that are supposed to be executed by this particular office holder, but we are being asked that it should be downgraded, Madam President. So in clause 6, Madam President, we see where clause 15 of the Act is amended by repealing subsection 2 and 3 and substituting the following. And Madam President, whereas in this subsection, we have 5 functions clearly outlined for the chief building officer, in the amendment that is being proposed here, that has been reduced, Madam President, from what I'm seeing, to 3. So this chief building officer is now going to be responsible, Madam President, for inspection procedures for building, forward breaches of building regulations, and then they said that functions that are already in the Act that the individual is already carrying out is repeated in section C. But in the meanwhile, Madam President, what goes, Madam President, is the following. Ensuring compliance with all building regulations. Monitoring all building and construction procedures to ensure compliance with approved design. Right, Madam President? And what is also going is submitting biannual and other reports to the National Planning Authority on the performance of its function in a form specified by the National Planning Authority. So, Madam President, we are removing functions from the chief building officer. We purportedly are adding functions that are already in the law, and we are removing functions under the provision that governs the duties of the chief building officer. And again, Madam President, we would like to have clarification from the Honourable Minister as to the rationale for this development, Madam President. Madam President, we know the importance of land use policies. We know the importance, Madam President, of development within that perspective. But I also would like to emphasize, Madam President, and it was argued by a colleague of mine, that one of the things that we need to pay attention to in the legislation is the whole concept of facilitation. Facilitation of development. And the question that is being posed, and some people are asking, is whether the Honourable Minister may not want to look at the establishment of a facilitation development unit within the structure that is being proposed. You see, you have a lot of controls, but this act is about facilitation of development. And we need to pay attention to that as well, Madam President. And maybe the Honourable Minister would want to look at that in the context of the National Planning Authority, Madam President. Madam President, I do not believe that we should be watering down or reducing the experiences that are required to give effect to this legislation. And that is what we are being asked to do this afternoon, so that it could be made easier to recruit people for those positions. So can I ask the Minister whether there are people out there that the government has already targeted to fill these spots? Are there people with 7 years of experience and they are already being targeted to fit this bill? And Madam President, what I couldn't understand as well, you met PricewaterhouseCoopers doing a project, they were employed to do an assignment. They were carrying out their assignments, according to the minister. But because it was a people's partnership government, forgetting that the Minister in the Ministry of Finance, before she became a minister in the Ministry of Finance, Madam President.
Senator Mark, just...
No, I'm not asking that. Worked for PricewaterhouseCoopers? So whether it was the UNC or the PNM, PricewaterhouseCoopers is a professional team. And we employ them, Madam President, to carry out an assignment. Why did the minister and the government discontinue the work of PricewaterhouseCoopers at the time, Madam President? And you know what, Madam President, what is more amazing? We are told by the minister the same PricewaterhouseCoopers was re-employed in 2018, Madam President. So why you discontinue them and then now have to re-employ them to do what? They continue a project? I think that is, Madam President, that is a kind of situation that we should avoid as much as is possible. So, Madam President, I saw a very interesting piece here. And I would like the Honourable Minister to clarify for me. Madam President, join me on Section 9, or Clause 9. We are being told that in the definition of professional governing body, in paragraph D, we should insert after the words urban and regional planners the word Trinidad and Tobago Council for urban and regional planners. And then, of course, we deleting the definition of simple developmental application or development application. I have been in consultation with professionals in this country who are planners, who are involved in urban and regional planning. And I have been advised, Madam President, that there does not exist in the Republic of Trinidad and Tobago something called Council for Urban and Regional Planners. I have been advised by professionals, planners, urban planners and regional planners, so why are we inserting into legislation a body that does not exist? And don't tell me it was done before. If it was wrong then, it is wrong now. I have been told, Madam President, I have been told that this body doesn't exist. So why are we being asked by the government to approve a ghost council? Well, if you did it before, I ain't doing it. I am not doing it. I am not doing it. I am not employing or I'm not approving or supporting ghosts. I know that ghost gangs, but I am not supporting ghosts. Since when? Long time. So, Madam President, I know for a fact, and the minister should be aware, my honorable friend should be aware, that on August the 4th, 2014, in the very Senate that the honorable member was a member of, and I served for some 20 years in. So I know about the Senate. I come like I make the Senate. I live in here. I know here. So I know about the Senate, Madam President. So Madam President, I am saying that on August the 4th, 2014, the bill, Madam President, was introduced.
Mark, you have 5 more minutes.
Thank you very much, Madam President. That's why I tell you I've been here a long time. And I not even enough. Madam President, so my honorable colleague would be aware that there was a bill that was introduced. And Madam President, there was something prepared called Bill Essentials that all of us are familiar with. And I have a copy of Bill Essentials here. And it states, Madam President, the Urban and Regional Planning Profession Bill 2014 was introduced and read for a first time in the Senate on August the 4th, 2014 by Senator the Honorable Dr. Deoroop Teemal. It was read, Madam President, but it lapsed after first reading when it was tabled. Apparently it never went through. For whatever reason, I can't say. But you know what is sad, Madam President? What is sad? The Minister of Planning and Development has been in office for 3 years and 6 months or 4 months or 5 months. We're going to 4 years. And Madam President, the bill that lapsed in 2014 is yet to reappear on this Parliament, in this Parliament. And what the minister is attempting to do is a shortcut, as we call it. The bill has come, so you know what I'm saying? I'm going to introduce the bill in this amendment. So that is going to do what? Maybe speed up.
You don't understand what's going on?
I don't understand what's going on. I know.
Minister, please.
Yeah, no, it's okay, but I can deal with this later.
Senator Mark?
Sorry, Mark.
Yeah, please. Don't respond to anything. Please continue in your presentation. You have been telling us how long you've been here, so you know what you should be doing.
And that's why I know. Yes. So, Madam President, I think I'm on my last few seconds. And I just want to indicate to my honorable colleague who piloted this bill, we are going to propose some amendments for your consideration. We believe, Madam President, that this bill being our bill, we want to say, so the Act of 2014 is ours, and the bill that is amending it is coming from there, that Act, Madam President. But there are certain weaknesses. You see, Madam President, when you do not design something, it's very difficult to really follow through, you know. The vision is not there. Remember, she following us. The Honorable Minister is following the government of the People's Partnership. That is what the Honorable Minister is doing. So I know there are some difficulties in conceptualizing and understanding the vision of the United National Congress and all those forces. So here I am in the Senate to give the support and assistance to the minister so she can better understand our vision that we have for the legislation. So, Madam President, we intend to propose amendments for the Senate's consideration so that we can have stronger legislation, more relevant legislation, and legislation that will benefit the interests and the general welfare of the citizenry of this country. I thank you very much, Madam President.
Senator Teemal.
Thank you, Madam President, for this opportunity to contribute to this bill and act to amend the Planning and Facilitation of Development Act 2014 and to consequentially amend the Environmental Management Act, Chapter 3505. Madam President, in terms of the proposed Section 3 of this bill, in the context of the definition for simple development, not a totally new development, not a totally new definition, I think I was said, because if we look at Section 73 of the existing Act, we would see that this definition is being brought forward from Section 73 under the definitions here, and I agree, it's probably more appropriate in this position in the Act. What I would like to say is that from the content of the definition of simple development, it seems as though the approach is to equate simple with small, because billboards, advertising signs, not more than gross floor area of 500 square meters, less than 20 plots, tends to suggest equating simple with small. But again, in the context of planning and engineering, simple could be very complex. Small could be very complex, sorry. In that small developments, the 20 plots, or just billboards and advertising signs, could be on poor subsurface condition soils. It could be in difficult terrain. And like billboards, for instance, in terms of the increasing size now, particularly digital billboards, could be susceptible to very high winds during hurricanes and all of these things. So small does not necessarily mean that the development is simple. And what this in the development of, in the definition of simple, really and truly, it is to negate the need for submittal of an application where it is prepared and submitted by a registered professional under this Act. So we may have simple developments that are of such complex engineering and planning challenges. For instance, a billboard on the side of the highway that borders the swamp, as is common going down the Uriah Butler Highway. That may require piled foundations, for instance. So by excluding or by trying to equate simple development with small development, we are running the risk by not having a category of simple development due to technical factors that require the inputs of a registered professional. And I think it would be safe in this Act if we could address that by saying that the National Planning Authority reserves the right, after considering a simple development, an application for a simple development, the National Planning Authority reserves the right to call for that application to be referred to or to be prepared by a registered professional. In terms of Section 5 of the proposed amendment, we come to the key positions under the National Planning Authority, this Act dealing with the National Planning Authority. And really and truly, when we read through the Act, the entire Act pivots around the three heads of department that's being addressed in this amendment: the Director of Planning, the Chief Building Officer, and the Chief Enforcement Officer. It pivots around these three critical departments. In fact, the Act only seeks to define the responsibilities and personnel surrounding these three departments. And what we are seeing here, what is being proposed by the amendment, is that for the Director of Planning, a reduction in the experience needed from 10 years to 7. Now, of course, there has been an addition with regards to tightening up on the specific qualification required by saying a degree, an undergraduate degree in urban planning and regional planning, and a postgraduate qualification in the similar field, or a combination of social, environmental, or design science undergraduate degree, but of course a master's in the urban and regional planning. And the question would arise, would that postgraduate qualification be equivalent to 3 years' experience to justify the reduction from 10 to 7 years? Madam President, in most professions, 1 year postgrad study being equated to 3 years' experience is very, very debatable, particularly in this field of discipline, particularly in this discipline. Madam President, if you will allow me just to refer to my notes here. We are speaking of head of departments for these three key positions. And the head of departments, as part of their duties, they are required to make decisions with far-reaching consequences on the successful operation of that organization. Heads of department also makes authoritative decisions and recommendations that are conclusive and have far-reaching impact on the authority that they belong to. Heads of department need to demonstrate a high degree of mature judgment in planning, organizing, and guiding extensive regulations of major consequences to national development. In this particular case, heads of department, they lead an entire program of critical importance, of national critical importance. They also decide the policies, procedures, and type of planning and engineering and other related sciences needed for accomplishing the objectives stated in this Act. Heads of department are also required to mediate on critical issues with top-level planners and engineers from other organizations and the private sector, including specialist consultants with far more experience than 10 years. And they are also required to represent the authority at major technical forums, both locally and internationally. Against the context of some of the basic requirements for these three heads of department, Madam President, I'm asking if against that, 7 years of experience is really adequate for a person filling these positions. Madam President, the American Society of Civil Engineers, they have graded the profession from grade 1 to grade 8. And it is interesting to note, if we look at the key requirements for heads of department that would come under directors, department heads, they call for postgraduate qualification and 15 years of experience. Now, let's scale it down, because we may say we're dealing with a smaller land area, you know, less challenges. Even if we are at a scale down, by comparison, 7 years really appears to be a bit on the low side for these departments of heads. I know our Honorable Minister of Planning and Development did say that the reason for coming down to 7 years from 10 years was that Price Waterhouse, in their Inception report or in one of their reports, advised that it would be difficult to get someone with 10 years experience. Madam President, the urban planning profession and the engineering profession, and also the Act allows for the chief enforcement officer to come from the legal profession. Within the Act, it also allows for the possibility of a legal person taking up that position with the right amount of experience and qualification. If with those professions established for decades, if we really cannot find such persons locally to fill these positions. Another point is that we have registered bodies here in Trinidad. We have registered the Board of Engineers. We have urban planning associations. And in terms of looking at the experience, reducing the experience to 10 years, I'm wondering what consultation were held with these bodies, with the existing bodies, in terms of the responsibilities of these heads of department under this Act. What consultations were held in terms of what those bodies would have recommended in terms of experience? Madam President, is it a case of relaxing our qualifications to allow persons to literally limp into a job? I ask. Madam President, I would like to go to Section 13 of the proposed amendments, in which the proposal to amend the first schedule of the Act is being proposed here. Particularly Section A, Section 2 of E, where it says, by inserting after subclause 3 the following subclause. The National Planning Authority shall appoint a chief executive officer who shall be an ex officio member and be responsible for the day-to-day management of the National Planning Authority. Madam President, the Act, Clause 13, Section 13 of the Act itself, deals with appointments of officers, in particular heads of department. And I'm just wondering, the question is, why are we seeking the amendment to appoint someone as key as a chief executive officer, to appoint them as an amendment under a schedule in the Act? And also, to give that person, that appointment, that chief executive officer, the position of ex officio on the National Planning Authority, when none of the heads of the department have that particular privilege or necessity. Madam President, when we speak of day-to-day management of the authority, really and truly, day-to-day management, we would be most familiar with in all organizations, really fall within the purview of an operations manager. And a chief executive officer is really charged with the responsibility and given executive duties and powers to really run, literally run the organization, and is really just accountable to the board. The heads of department under this Act, if we read the Act and look at the responsibilities of the heads of the department, we would see that they are the ones that are responsible for the day-to-day operations of the proposed National Planning Authority. The powers they have been given and the duties assigned to them under the Act strongly suggest that the intention is that the heads of the department would really be, that's the chief planning officer, chief building officer, and the chief enforcement officer would really be responsible for the day-to-day operations of the National Planning Authority. So if we are proposing a chief executive officer who is charged with the responsibility of the day-to-day management of the authority, how is that position and how is that person going to function and interact with the heads of the department? And I think it deserves to be given a lot more consideration. Is the chief executive officer, without their responsibilities and their duties being spelled out here within the Act, is the chief executive officer going to assume those responsibilities and duties? Going to be directly responsible when the Act specifically pinpoints the chief building officer and the chief enforcement officer with certain duties and responsibilities to ensure planning approval, planning compliance, construction compliance, and building compliance under this Act. Madam President, it is very brief, this amendment about the chief executive officer, and reports to who? Who would the chief executive officer report to? How much executive powers would be granted to the chief executive officer? And as I mentioned, in terms of how much is it going to conflict with the responsibilities of the three key heads of department? The qualifications of the chief executive officer, there's no mention here, but the amendments pay a lot of attention to qualifications. And there's no mention here of qualifications, experience, or professional registration as per the heads of department. In clause 14 of this Act, Madam President, it states specifically in clause 14 that the National Planning Authority can delegate such functions of the National Planning Authority as it sees fit. That section is specifically written into the Act, where the NPA, National Planning Authority, can delegate as it sees fit any function. And I'm asking the question, if that coordinating role of the necessity of a coordinating role to coordinate the work of the authority and the various departments is a necessity in order for the proper functioning of the proposed authority, rather than create a new post of Chief Executive Officer, would, under Clause 14, an appropriate delegation of further functions to either of the three department heads would fulfill the intention of having a Chief Executive Officer. Madam President, other than those comments, I think in terms of the other amendments that are proposed, some of them, as our Honorable Minister for Planning and Development said, may seem minor, but I agree with her. I do agree that they do have an impact on the functioning of under this Act, and I would support those amendments. I thank you, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President, thank you very much for the opportunity to join the debate on this bill, which seeks to amend the Planning and Facilitation of Development Act 2014. And my colleagues on the other side, Senator Mark, on behalf of his colleagues, have already claimed ownership of that bill. Madam President, I listened attentively to Senator Mark, and there are about 7 areas that I just want to respond to very quickly. Both Senator Mark and Senator Teemal have focused on the changes to the minimum level of experience being reduced from 10 to 7 in this bill. And Madam President, my view is that the threshold is being lowered. It doesn't make it mandatory that someone with 7 years experience is going to be recruited. In fact, nothing in the bill even suggests that there is somebody selected for these positions. All it does is that it brings to bear on the legislation the experience that some of us have had in the public service. The fact is that sometimes we fix entry levels into public service positions which make it very difficult to recruit people, because after a certain time, after they have gathered a certain level of experience, they move on to other places. Many times in the public service, in our experience, you have positions, particularly technical positions, where it is impossible to find people because those persons who have gathered a significant amount of experience move on. And Senator Mark knows. I'm sure he has had to take notes, or he has been in a cabinet where notes have been brought to suppress public service positions because we cannot attract people who meet the minimum threshold because the threshold is set so high. So all that does, and it also recognizes, Madam President, that when, as a country, we took steps to encourage persons who had been in the public service for long periods but had not graduated from a university, somewhere in the mid-2000s, there was an aggressive, through gate and otherwise, there were aggressive steps to get public servants into the University of the West Indies, upskilled and graduated. So you may find in the public service very experienced public servants whose period of postgraduate work is very short, but they are experienced. And some of them may be able to take up these positions if we lower the entry level. This doesn't water down the brandy, Senator Mark. I am not an expert in brandy. But what it does, it changes the entry level, the minimum threshold. And we ought to leave for the recruiters the decisions based on what is acceptable in terms of a candidate. And I assure you that the government has no horse in the race. We just want to fix the legislation. The second point I want to make in relation to Senator Mark's contribution, if you focused on Clause 6 and accuses us of removing some of the functions of the Chief Building Officer. Madam President, we've done no such thing. The amendment that is proposed, the government is proposing that where subsections 2 and 3, if you go to the Act in which my friends have claimed parency, if you go to section 15, you would see at subsection 2 and 3, there is an attempt to be very prescriptive in terms of the functions of the Chief Building Officer. And as Senator Teemal has correctly pointed out, the Chief Building Officer has significant responsibility under the Act. And all we've done is that we've included, by removing subsection 2 and 3, we are proposing a replacement of subsection 2 by a new subsection 2. And if you look at the proposed subsection 2C, you would see a specific reference to sections 62, 66, 67, 68, and 70 of the Parent Act. And I don't want to painfully go through, because, Madam President, a few seconds in you'd stop me. But if you go to the Parent Act, and the parents are sitting there, if you go to section 62, you would see section 62 deals with the responsibility of the Chief Building Officer to approve certain plans of the Parent Act. Yes, section 62, right, and at subsection 2, 62.1, you would see the Chief Building Inspector has a responsibility to approve the procedure for issuing and the method for authenticating any permit, notice, or other instrument. You would see that the exercise of the functions of the inspector is subject to review by the Chief Building Officer. If you go to section 66 of the Parent Act, your Act, you would see at 66.4, the Chief Inspector may order that any part of the construction of the demolition or so on. If you go to 67 of the Parent Act, you would see at 67.1, the Chief Building Officer may issue any order prohibiting the covering or enclosing of any part and so on. You would see at 67.2, duties under the Act being assigned to the Chief Building Officer. If you go to 68 and 70, the point I'm making, Madam President, is that by reference to these sections, and my colleague, Minister of Planning, has said that there is no value in duplicating. And what we've done is that we've set out in the new 15.2 some specific responsibilities which are set out at the new 15.2A and 15.2B, and we've referenced the other responsibilities
which are contained in Section 62, 66, 67, 68, and 70 of the Parent Act. And I know you're happy for that clarification. You're happy that the brandy remains strong, and you're happy to support the amendment, which you misunderstood up until a few minutes ago. Thank you very much.
Honourable Senators, at this stage we will suspend the sitting and we will return at 5 p.m.